members of the forum, members of the public. As I listened to the various contributions, and particularly the last speaker, the only thing I could think of our present prison system comes from Dante. Abandon hope, all ye who enter here. I therefore come to the immediate conclusion: implementation, performance, and effectuation is what we need now. Remove all the impediments, including, Mr. Attorney General, the fears of a constitutional backlash. There is no longer the other side. There is only one side, the public side. Let us defend the public interest together. Mr. Israel Khan, Senior Counsel, Malunid Senior, I disagree with you on one point. I am of the view that the criminal justice system has collapsed. There is no justice for poor people in this country. The failure to provide swift, effective justice and proper model penal systems has only created, not an incubator, Mr. Commissioner, a pressure cooker that is exploding on us and on those who serve our system. It has led to murder and mayhem. We have failed to understand in the last 71 years that criminals require rehabilitation, and we can no longer get away with locking them up and throwing away the key. They return to society. Remandees, Mr. Khan Jr., I have two difficulties with. One, I fully agree that the prisons are ill-equipped to deal with remandees. But remandees are not only awaiting trial, they are now there as a result of a legislative program, as a crime prevention method. Those who are charged with certain crimes get no bail. That is not the answer to our problems. We must understand the pressure cooker system, the failure of proper rehabilitation systems, and the retraining of our prisoners will only lead to increased rates of recidivism, which I am instructed, and I take from the commissioner's, the inspector's report, is now at between 56 to 71%. And by recidivism, I mean those who return to the prisons within 3 to 5 years of being released. In other words, they are not ready to engage the system. The time to talk is over. The time to plan is over. The time to implement is here today. Bear with me as I take you on a historical journey as to why I have concluded that. In 1943, as you know, legislation was enacted that reflected the social and juridical views of crime and punishment at that time. 2 years later, 1945, the first of 9 reports on the prisons began. 71 years later, in 2013, a task force report is presented for the second time to a cabinet. Mr. Richards, I understand you. Nothing happens in 71 years. The 2013 task force report is now succeeded by the 2015 United Nations Mandela rules on treatment of prisoners and prison officers. They are related one to the other. You cannot separate the prisoners from the prison officers. Correctional officers must be trained, and they must know how to deal with prisoners with dignity and understanding and respect that one day those people must go back into society. I want to publicly thank those who have sat for 71 years on all these commissions pro bono without pay to produce reports that collect dust on shelves. And I'm grateful, Mr. Attorney General, for your sentiments that that dust will finally be removed and will finally see the light of day with proper prison reform. I note that the first UN resolution on proper treatment of prisoners was in 1955. And we are not backward here in Trinidad and Tobago. In 1968, former Chief Justice, the late Sir Hugh Wooden, addressed the need for prison reform in Australia at a conference. I shall return to his address because he made recommendations in 1968 that are relevant in 2016. And I intend, before I leave here, to list recommendations which I feel, on behalf of the Law Association, will assist us in reforming not only the prison system, but the criminal justice system. We must now look, Mr. Attorney General, at the 2015 Mandela rules in December last year. It starts by protecting the rights of prisoners, including those who are awaiting trial, either because they cannot access bail, they are too poor, or they are there because legislation puts them there. Former Chief Justice Sat Sharma opined that a number of our prisons belonged in the dark ages, and you've heard the comments of Madam Justice Gobin just a few years ago. So going back to the beginning of our juridical history, we have known that our prison system could not work. I caution that placing human beings into an uncivilized and inhuman condition has the effect of dehumanizing them. They return to society as animals. And it is no wonder that our recidivism rate, that is, reoffending rate, is between 51 to 66%. It is way too high. In the United States of America, with a larger population than ours, it is 56%. How come in a country like Norway, it is 4%? With 4 times the population. The cornerstone of Norwegian and other Scandinavian philosophy is respect for the prisoner, respect for the correction officer. May I express to you, Mr. Attorney General, from the Norway prison correctional facilities, the philosophy they have. For the victim, the offender gets justice by the person being sent to prison. That is justice. Here, in this prison, we give prisoners respect. This way, we teach them to respect others. But we are watching them all the time. It is important when they are released back into our society, they are less likely to commit more offenses. That then becomes justice for society. We as a society in Trinidad and Tobago must understand that we can no longer take the philosophy, lock them up and throw away the key, dump the rubbish in the prisons. That is not going to work. They come back home to us. The question is how? And that is where I applaud the Attorney General for saying implementation will be the form and the way forward. In closed prisons, we lock them back up, but we give them the responsibility, washing, cooking, learning. Being sent to prison has nothing to do with putting you in a terrible place to make you suffer. The punishment that the law foresees is the loss of your freedom. If we continue to treat people like animals, as I said, we're going to get back those animals. The figures of recidivism in Trinidad are unacceptably high. 3,665 persons in prison, 50% awaiting trial, 97% of which come from the lowest poverty classes. That is an income of under $655 per month. How can we as a civilized society tolerate a man being in prison for the length of time for obscene language which carries a $200 fine as the maximum sentence, or for maintenance, or for a ticket? Dante is right. We are in purgatory. We have collapsed. We also understand, as members of the Law Association, that there is a relationship between the prison system and the dispensation of justice, and therefore reform must go hand in hand with our criminal justice system in an effort to deliver swift and proper justice to the people. We cannot tolerate the prisons moving from a place of confinement for the commission of a crime to the place of a detention without bail of human beings, to any place of dehumanization, and I accept that it must be separated. They are two different things. Remand yard, up to today and into the foreseeable future, is a dark and bleak blotch on our civilized conscience. It is no longer punishment, and not even revenge can describe the conditions that are described in the inspector's report or have been described here by my learned and noble friends. We are beyond the lowest point. You have heard talk about the principles of sentencing. 1943, the underlying principle of sentencing was retribution, coming from the Old Testament concept of an eye for an eye and a tooth for a tooth. Chief Justice Wooden, as he then was in the case of Benjamin and the Queen, perhaps one of the most notorious cases to ever pass through this country, where a man kidnapped and kept and tortured two young girls, removing from them their sight in the most horrendous of ways, indicated that such no longer played a part in our law way back then. That because people must return to society, it is a time for us to modernize. Long sentences are of little value to retraining persons. People must return properly with the time for them to live and pay their debt to society. Can I go back to Chief Justice Wood in 1965? In his book, A Collection of Addresses, Sir Hugh Woodin recommended prison reform. He stated, "To those who adhere to the traditional concepts and think that a sentence should be primarily related to the gravity of the offense, rather than its probable future consequences, that can no longer be the order of the day. Justice must no longer be blind. It must now dispense sentencing according to the offender's need, rather than according to society's desire." Chief Justice Woodin opined that retributive justice, traceable to Roman concepts of lex talionis, should give way to restorative principles, and even suggested that an African bondage system of punishment may now replace going to jail. By this theory, a person convicted of an offense would be required to provide sustenance to the victim and his family in repayment for the wrong he has done. 1968, he further suggested that daytime indeterminate sentences must now be replaced, or must now be brought into place, which suggested work for profit for the community by prisoners, with a right perhaps to even go home on weekends, and the requirement for compulsory psychiatric treatment for all offenders, because something must be wrong, and if something is wrong, now is the time to correct it. He emphasized that correctional officers needed to be trained in diagnosis and the treatment of offenders in prison to spot the difficult ones who might need help. These sentiments of the Lord Chief Justice have been repeated in the judiciary on a number of occasions. In fact, I proudly say that His Excellency the President, while sitting as a judge of the High Court, in looking at pre-trial detention, created a system of monitoring in matters of bail with young people, so that they will not have to stay in jail for the foreseeable future. Justice Lucky has implemented a system of monitoring not seen in this country, where people are not sent back to prison but are taken out, and once a month they report back to court, where they are kept abreast of what has happened. We cannot keep imprisoning people, ladies and gentlemen, with no hope of trial for years to come. That is the pressure cooker that's causing murder and mayhem about our correctional officers. Because people ask, well, why? Well, that's the reason. Somebody is blamed. Somebody has to pay the penalty. You cannot continue to use the court system. We have to find practical ways of pre-trial release and a bail system that's easily accessible to the poor man who makes up 90% of the remand population. Madam Justice Lucky has indicated the attachment of conditions to bail may be wrong in the absence of evidence that the person is a flight risk. Conditions are attached to bail daily for no reason at all, without any evidence. That is wrong. Perhaps it is now time for simple answers to what are really not so difficult questions. There is no need for us to reinvent the wheel. It took us a long time, by way of example, but we now know, for example, that drug addicts don't belong in prison. Those who use marijuana are not deserving of sentence. Well, the logical thing is decriminalize those kind of offenses. Bring it to an end. Take the step further and create a fixed penalty system for minor offenses. Don't even take it to court. We do it now for motor vehicles. So a man who went on the streets and used obscene language for whatever reason, give him a ticket, go and pay it. $200 fine. And a number of other matters. Take it out of the court and declog the system. The backlog needs to be tackled and removed. Mr. Khan Sr., I agree. 700 capital matters. And how many matters that we don't know about in the system? Rape, robbery, whatever else that we have no idea about. Perhaps it is time we consider an amnesty. Or secondly, a plea bargain system, followed by an indication of maximum sentence that really is a plea bargain system. It may be necessary to introduce the no contest system that happens now in the United States of America. One of the difficulties with the plea bargain system, Mr. Attorney General, is you have to be guilty. In the number of years that I have been a defense attorney, I only think it's on 2 occasions I've actually had instructions that my client was guilty. If your client tells you he's not guilty, no plea bargain. But there are a number of matters on the books where people will offer no contest to a matter and will pay a fine with a chance of nullification. Let us bring it in and break the backlog. And Mr. Khan is right. If we had classification of murder, well, a lot more people will plead guilty to manslaughter. And I'm sorry to say it, but the murder felony rule reenacted in this country must be removed. It's wrong. The Privy Council said so a couple of weeks ago in the case of Jogi, when it said specific offenses require specific intent. Not only will you will remove the backlog, you might get witnesses. It would speed up the process. Now, getting rid of the remandees, that is not a difficult problem either. We already have legislation for wearing of bracelets. Well, let's use it. Where are the bracelets? Bring them. Let us have people under house arrest, monitoring of persons from non-capital matters, all of them. Create a system of professional bailers who will keep tags and monitor persons who qualify for bail but do not own land. The biggest open secret is that it already exists in an illegal format in this country. Let us legalize it. Let us take out those who don't belong in jail. Let us ease the pressure cooker from the prisons. There is no doubt that we need to staff properly the Office of the Director of Public Prosecutions. We need to abolish preliminary inquiries, Mr. Attorney General, and go back to the days of direct committal. Let the Office of the Director of Public Prosecutions commit directly to High Court all matters, with the power in the defense to move to strike it out if there is no evidence before a High Court judge. Why are we wasting time with this two-tiered system and creating delays of 16 years, Mr. Richards? It's terrible. Remove the need to go to court. I think it's 15 years ago, there was a report by Mr. Justice Mark Mohammed on remand yard and the establishment of a remand yard court. Mr. Attorney General, I'm grateful to hear that it's been implemented and it only took 15 years. It's even easier than that. There is a cost-saving exercise. Now, don't quote me on this, but I understand the cost of transporting prisoners is about $60 to $80 million a year. Am I correct? Yes, I'm correct. I don't have the If you put simple video reconferencing in, that solves the problem. There are simple truths. There are simple solutions. I have looked at the various reports, and again, I offer my congratulations and sincerest, I don't know how, adulation to those who have so given tirelessly over the 71 years it took for us to have a forum like this. But I've also noted that it is time for our academics to step up to the plate. Since 2013, study by academics on the effect of the prison system on prison officers and how they interact with prisoners. And I pay tribute to Mr. King and Dr. Bartholomew of the University of the West Indies for carrying out the only such study locally in 71 years. It is time for us as academics to step up to the plate as well and ensure that our recommendations are there. May I suggest a simple and practical procedure in keeping with the 2015 Mandela rules and what I understand to be modern correctional practice? Of course, I'll be corrected if I'm wrong. Upon arrival at all prisons, new prisoners must be told in a language in which they understand and given guidance on prison regulations, including their obligations, and be given access to lawyers. If not the legal aid, Mr. Khan, it might be time to put an office inside the prison so that people could get advice there. Because only 2 weeks ago, there was two months ago, there was a case in the High Court in Port of Spain where lawyers could not get access to their clients, and vice versa, in an emergency matter. There must also be a procedure and advice readily available to inmates for the reporting of injuries and allegations of ill treatment by prison officers. The other side of the coin. Prisoners must be advised of the facilities for confidential meetings with lawyers of their choice and be allowed access to and the retention of papers connected to their cases. Prison officers and prisoners must know that instructions to lawyers are confidential, and the prison officers are not allowed to have copies of those things. That is a breach of the law. On the other hand, lawyers must know that it is an offense to provide contraband to prisoners. and to advise them how to commit crimes for which they should be or lie down next door to the prisoners in Mr. Khan's graphic presentation. There is time now, and I'm grateful to the Attorney General, to place an independent complaints authority, not like the police complaints authority, where prisoners could complain with the belief that they are going to be heard and will be heard independently. Not only the prisoners, but the officers as well. Both sides. Annual Inspector of Prisons report, 2012 to 2016, Mr. Khan. We need that, and we need to be made public in consultations like this so we all know where we're going. Mr. Richards is right. We are accountable to the public. We will account in public and not behind closed doors. Let us not worry about the catastrophe if we fail today. But if we fail in the initiative today, Mr. Attorney General, I certainly will not be here to deal with the public outcry that will come in 52 months' time. Can I make it in point form very quickly, because I know it's been a long afternoon? Restorative justice must replace retributive justice. The 1940-plus rules, gone. Can't work. Imprisonment must be dignified and not amount to depriving of constitutional rights. It must include the right to access to your family. It must we must remove the impediments from legislature that don't allow prisoners to work. Let them work. Let them make an income. Let them use their incomes when they come back out from prison to start life afresh, if not pay compensation to the victim and their families. This will have two effects. It will teach the prisoner responsibility when he becomes a member of society, and it will be a lesson that wrongdoing don't pay. You have to work. Not only that, I have been the recipient, Mr. Commissioner, of your bread from your bakery. I have seen the agricultural produce from the prisons. All these things can now be used as people are retrained. There must be proper psychological and psychiatric assessments of all prisoners. But not only prisoners, victims and officers must be the recipient of ongoing help to deal with the psychological trauma of having to deal with crime within the prison walls. It must be horrific for officers and my fellow citizens to have to separate men in sexual engagements and practices. But it goes on, and we don't say it publicly. There must be the development of halfway houses with employment opportunities, and in the deserving case, the ability of a prisoner to re-educate or retool themselves in order to reintegrate. The commune system that Mr. Khan talks about, I agree with fully. But it must not be a commune of prisoners only. That's just opening up the doors of prison. It must be a halfway house so that people can meet their families, can have a life, and get ready to return, can earn. Perhaps assistance from the government and the private sector with regard to the development of small cottage businesses. There is a need for ongoing professional training for prison officers in proper correctional methods as it changes. The mere fact that internationally, and we as signatories to the United Nations Convention, passed a law in 2015, December last year, called the Mandela rules on how to treat prisoners. But we are talking about 2013 rules coming in. Perhaps before you actually bring it, Mr. Attorney General, it might be wise to compare the 5 principles of both sets. May I suggest the short-term solutions? Amendment to the bail legislation to make bail more readily available, and the creation of the professional bailer system, perhaps monitored by a probation office. The appointment of temporary magistrates and temporary judges immediately to deal with the backlog that's in the High Court and the Magistrates' Court. A review of all prisoners who serve more than 4 years with a view to a sentence review, as is now allowed under the law. A review of all prisoners on remand yard, which has already been done from the Learned Attorney General's presentation, to see whether or not they can be taken out immediately, either by plea agreement or by a grant of amnesty or pardon. How can you justify a man being inside there for 5 years or 3 years on an obscene language charge? How is that criminal? Cannot be justice, cannot be in the public interest. I've already indicated the creation or the consideration of a proper amnesty. Perhaps we can do as in Jamaica, money for the guns. You bring back your gun, we give you money. And we won't charge you because we really want to get the guns off the street. I've already pointed the creation of the video system, and the Remand Yard Justice Mohammed Committee report is there. Again, no need to invent the wheel. The legislation is already there. In circumstances where there are men's freedom, and I'm sorry to put it this way, in the magistrate's court, if bail is denied, or if conditions are attached, or if approvals are necessary, or if a passport has to be surrendered, the only option you have is an application to a judge in chambers. Well, guess what? If you happen to have a bail hearing after Wednesday, you're in trouble. Because if you don't get the application in by Wednesday lunchtime, 7 more days in jail for you. Or such other time as it can be listed. Where a man's liberty is at stake. There should be a system in place in the High Court to immediately walk across to the High Court from the Magistrates' Court or the Magistrate's decision. Let us determine whether there's a need for pre-trial detention more than is necessary. These people are innocent, following the golden thread. The midterm objective, therefore, Mr. Attorney General, would have to be proper plea bargaining legislation, which I understand is ready, and the creation, perhaps, of the no contest system. People will not challenge if there is no conviction recorded. I suggest, finally, that the recommendations of the task force be implemented urgently. And I don't care which side of the fence you are on. There is no longer the other side. It is going to be up to you, the members of the public, to get behind the members of Parliament in every area and make sure they do not allow special majority voting in Parliament to hinder the way forward for this country. It is time that we act in the public interest for a civilized society. The reverse is unimaginable catastrophe, not for me, not for you, but for our children. A delivery of swift justice will mean a reduction in the crime rate. Mr. Attorney General, I thank you for the opportunity for this public consultation.
Ladies and gentlemen, I've been a member of the Law Association for quite some time, until recently wearing a different position now. And to the best of my ability, I just can't recall anyone from the Law Association speaking on this issue at all in recent memory, publicly, other than by way of closed door or small gathering occasion. And I would just like to point that out, because what we've just heard from the Law Association and from a very seasoned practitioner in this arena of the law, has been nothing other than extremely powerful. And I wish to compliment the participation of the Law Association and for the very excellent delivery brought by Mr. Rajcoomar. I'd just like to say in answer quickly to the short-term solutions, which you'd be pleased to hear. Bail amendments, prepared. Professional bailer position, in preparation. Temporary judges and magistrates, actively considered and discussed with the Chief Justice, being operationalized. Review of the sentencing position, already in tow. Remandees to be taken out, that's why we're here, to create the groundswell in relation to certain aspects. Amnesty, significant discussion has to be had. That's Section 34 done right, if one were to think about it. Video remand, on the way, nearly there. No contest system, already in gear. You see, to the Law Association and members of the public, we haven't been sitting on our hands for the last 6 months. We've been doing a lot of active work, and it's only occasions like this that allow us the opportunity to share with the public what it is we've been doing, but more particularly, having put it into the public domain, to be held accountable for what we say. Ladies and gentlemen, in swinging the pendulum back to institutional arrangements, may I first of all compliment the Commissioner of Police for sitting so calmly during this event. Once he's here, Trinidad and Tobago, I know, may be looking for him in other quarters because he has a hard task. He is himself an attorney at law. He is a man with the responsibility under the Constitution of Trinidad and Tobago for the management and for the financial management included in that in Section 123 of the Constitution of the Trinidad and Tobago Police Service. His is not an easy task. He's the gentleman who's called upon to receive every complaint and to receive all blame, something which I have a problem with because I think that we need to parade out the structures of authority. This is just a very personal reflection, as opposed to the personification only of it. So may I, without further ado, introduce to you and ask you to welcome to the podium the Honorable Mr. Williams, who is our Commissioner of Police, to speak to us.